Hi, Christine Faulkner, estate planning attorney with Cava&Faulkner here in Elk Grove. And I'm here with Lana Shearer with Shearer Law and Mediation in Elk Grove as well. And we're here for another edition of Family Matters. So today we're going to talk about documentation, which, being lawyers, we're intimately familiar with documentation. Many people think that working with an estate planning lawyer, that's all it's about, right? Walking away from the planning with a binder with the papers, but really, working with an estate planning attorney is about so much more than just having a pile of papers, but it really is about working with someone who can give you some very important guidance in creating the plan that you need for your family. And so, but documentation is so important all the way around in the legal profession. And when I'm working with clients to create a plan, we're documenting, their choices of guardianship in both their will as well as the kids' protection planning, standalone documents naming both temporary and permanent guardians. We have some other documents that are associated with that as well. What does the documentation look like from a family law perspective to start a guardianship proceeding? So let's say, for example, my clients are incapacitated. So they're still alive, but they no longer have capacity to care for their children. What happens on your end of things to get things rolling?
So there's a petition for guardianship that you would file with the probate court. And that petition lets the court know what the reasons are for requesting this guardianship. What has happened, details about that, and also lets the court know that, why you would be the appropriate guardian. And also you have to tell the court who the other potential guardians would be, because they need to receive notice of your petition as well. And then, of course, the court will appoint a probate investigator who will then investigate all of these matters that you're telling the court have occurred, which is why these children need a guardian. So it all starts with a petition for guardianship, and then that will get you a hearing and get you an investigation into the matter.
And so, as we've talked about in prior recordings, when I'm working with clients, especially a married couple, their guardian documents are going to be identical, other than they're going to have the opposite names, but they name each other. Of course, the spouses and biological parents are obviously the first choice, but if they're both unavailable, we have created these documents. And I think, as we've also discussed, having even more documentation beyond just the choices of those people and why would be useful pieces of information to take into that guardianship proceeding. Do you agree with that, Lana?
I do. I think the more information you can contain in your estate plan, specific information as to why you have named a particular person as the proposed guardian for your children, and also why you have considered other relatives and why they were not chosen. I think having specific information in there about that choice and why you made it would be helpful for a court who is later, going to be making these very important decisions regarding your children. And if you aren't available to testify as to why this particular person, Aunt Betty, is not who you would choose for your guardian, well, why? And those reasons should be included in your estate plan.
And just out of curiosity, is there any degree of relationship that is sort of like a default? So if parents are not available, do they automatically sort of look at siblings or grandparents, and do they have or is it really just who's best?
Well, it is. There's the biological connection is going to be the first one they're looking at. So maternal grandparents, paternal grandparents, aunts and uncles. If there's older brothers and sisters who are, over 18, those would also be, potential choices. So the biological connection would be preferred, and that's where the court would start, and that is who is required to receive notice of a petition. But there could be other important people in the children's lives, that you have bonds with, godparents, or, just best friends of the parents that they may want to have as guardians that aren't relatives. And so if that is important to the parents, they should include that in their estate plan.
So it sounds to me like there's no sort of default. There's no like, oh, well, the first choice would be the grandparents or the first choice would be the siblings. It's really a matter of the totality of the circumstances and the facts that the investigator discovers. Is that right?
It is, yeah. I mean, it's going to be important. They have to look at the facts of, this child's life. Has this child lived in close proximity to the grandparents, or have they lived, next door or even in the same house with, another relative? All of those, facts are going to be important in deciding who has a close bond with these children and who would be, the most appropriate guardian.
And I just had this question pop into my head. And so what if like you have two sets of grandparents, one from each parent, right, who are vying for guardianship, and one lives out of state, but they've kept a very close relationship with the child or the children. Is there a preference there, or is it again the same analysis? Doesn't matter where they live.
I think the strength of the bond is going to be key. Even if you only see them, 3 times a year, but during that 3 times, it's for an extended period of time, and the children are particularly bonded with those grandparents. And in between those visits, they speak every night on the phone or quite often. The investigator will speak with the children and will speak with both sets of grandparents and make recommendations based on what they find from those interviews. And they're very telling. Children are usually very, it's not hard to see who they're bonded with.
And we all see this on TV, but how old does a child have to be to actually be talking to the investigator or giving credible evidence?
Typically 5 and over. They typically would not interview a child under 5. But it depends on the facts of the case for sure.
Interesting. So what other documentation comes into play in terms of guardianship proceedings that are important for our viewers to consider?
One document that I wanted to tell you about, I find to be really helpful, and most people don't even know it exists. It's called the Caregivers Authorization Affidavit. And it's a California form that allows someone who's in charge of caring for that child, but there's no guardianship petition in place. There's no custody order. There's nothing that gives that person written authorization to provide that care. But for some reason, circumstances are that child has ended up in their care. Many reasons that happens. So this Caregivers Authorization Affidavit is something that person who's caring for the child can complete with all of their information and give to a third party. It's typically a school or a medical care provider. That child needs attention or needs to be enrolled in school, but they don't have any orders giving them that right. They complete this document and they give it to that third party. The third party can use that as kind of a shield against liability. Like, I relied in good faith on this caregiver's affidavit, and I enrolled the child in school, or I provided medical treatment. And it's something California allows, because you don't want someone who's in charge of a minor child to not be able to get medical care or not be able to get the child in school. It's a really helpful form, and many people don't know it exists. If you are just considering filing for a guardianship petition, because the children have been with you for a little while, and it might be long term, but you don't yet have your orders, you can still use this caregiver's authorization to enroll them in school and get things done that you need to have done.
Nice.
Really
Yeah,
useful.
yeah, and one of the things that we talk to our clients about is that the practical part of planning, which is not necessarily what we have written on the page, but how easy or hard it is going to be for people to jump into action for them. And so that's the more practical part. And that sounds like a really important practical piece to enable somebody to act in the best interest of the child and also get things done, right? And the third party is shielded from liability in acting in good faith on this written documentation. And so we have something that's different but similar in some ways, where part of our kids protection planning is to create a medical power of attorney. So we have the legal documentation from the parents naming guardians, naming the people they think would be important and the best guardians if they were not able to parent their children. We also create a medical power of attorney. So it's slightly different than what you described because it's the parent completing this, allowing a third party to get authorized medical treatment for their minor children in the event they become incapacitated. They could actually use it even if they went on an extended vacation, right? They could execute this document and allow maybe the grandparents or a third party who is watching their kids during their absence. They could authorize them to get medical care on behalf of their children. And we also have what's called caregiver instructions, and it's really just kind of a practical part of the planning that we do, which is giving information to a caregiver for their minor children about where they go to school, who their medical provider is, who their dentist is, what kind of allergies they have. So we really have tried to build a robust planning, which is not just the legal, but the practical part of planning so that people know what they need to do, but also have the information they need to have to act on, in the best interest of the kids, even if it's not the parents, if it's a temporary or a permanent guardian. So interesting how documentation can be really important to effectuate the best plan for the minor children.
Yeah, documentation is key, especially if there's going to be any court proceedings whatsoever. The strength of your documentation can, make or break your case or your claim. And so your documents should definitely be robust. And it sounds like you're doing everything you can in the best interest of these children, and that's fantastic.
Well, I wanted to say one other thing. So if there's ever a guardianship proceeding, there's two kinds of evidence, written and oral. And a witness testifying in front of a judge, and that's the oral. And then the written obviously is a statement. And so our scenario presumes that the parents are not around to give oral testimony. And we've talked in earlier videos about the importance of written documentation. Besides like a written history from a parent, is there any other kind of written documentation that would bolster a guardianship proceeding to help a parent maybe have the people that they chose as guardians, other people who could testify or who could write something for them?
Sure. I mean, witnesses would be important. So if the person who is making the statement is no longer here and available to testify, then you're going to want to get some corroborating, evidence. You're going to get someone else who can support what the deceased person has put in their document. So witnesses are important. The problem with, written declarations or written affidavits that are submitted is that you can't call that person to testify and cross-examine them. So that's what we always want to be able to do is oral testimony given in court is available to cross-examine. And when you have someone who's deceased, you can't do that. So in order to strengthen, if someone had some allegations in their estate plan about behavior of another parent, or their reasons why they didn't want a particular person to be the guardian, having some witnesses, other people who were knowledgeable about that. Of course, witnesses, you can't create them. They happen. Either someone has witnessed behavior, but I think if you put in your estate planning documents the names of those witnesses. So these are my statements, this is what happened. But not only that, John Doe was there and James Smith was there. Point out who those witnesses would be, because otherwise, how is the court supposed to know if you don't set it out in writing?
Yeah, and so it would be good maybe to have written witness statements if you can acquire them in real time that are signed and appropriately authenticated, as we talked about, with a statement under penalty of perjury that the foregoing is true and correct, and witnessed or notarized. And because that obviously prevents, what happens if that witness passes away and they also can't testify. At least you have something in writing. Again, you have the due process issue or the right of cross-examination of that witness, but there may be certain circumstances, one of which is, I think, the unavailability of a witness, where that written statement could be admitted as evidence.
Right, and absolutely, it can be admitted. But if you want the stronger, arguments, and it's really important, the more witnesses and affidavits that you can provide would be helpful in strengthening that argument.
Excellent. Well, as always, you've provided really useful information to me and for me to actually better guide my clients in this process of estate planning. So thank you so much for your information and expertise in family law.
Well, thank you. It's great to be here. I look forward to the next time.
See y'all next time.